Good morning, everyone. Good morning, good morning. I hope that everybody is well. Welcome to our Women in Sectional Title webinar. Thank you so much for carving out the time today to be with us. I really appreciate it. We're given to understand that this has become a fantastic forum to share relevant and up-to-date information. And if you can leave with just one new thing that you've learned, some practical tip or advice, well then, job done. So it's always been our vision at Women in Sectional Title to create an easier and more streamlined life for owners, for trustees, and for portfolio managers. Most of you on this platform are portfolio managers. So thank you for educating yourselves and coming out. But our vision here is underpinned by an ethical responsibility to also contribute positively to our industry, our precious sectional title industry, and just to improve things. And navigating together with us on this journey are our valued sponsors, of course, ZFIN, CIA, Meeting Pal, BCM Track, Sectional Title Solutions, We Connect You, and our new and latest sponsor is PKF Octagon. I'd like you to just read a little bit about them to you. PKF Octagon provides complete audit, accounting, tax, and consulting services to meet the specific reporting and financial needs of all residential and commercial bodies, corporate and community schemes. They are proud members of PKF International, a global family of independent firms bound together by a shared commitment to quality and integrity in a complex regulatory environment. So thanks so much, Monique van Wyk from PKF Octagon and Alistair Scholz for facilitating the onboarding of our new and really valued sponsor. Thank you to all our sponsors. So today we're talking about the Occupational Health and Safety Act 85 of 1993. We need to talk about whether or not trustees are bound by this act. Who does the act actually apply to? Is it, contractors, trustees involved with it? What do trustees need to be thinking about at this point in time? And certainly, I think, how are legal obligations to be met with all these various rules and regulations in place? It's quite a regulatory environment, and there's no better person to talk to us about it today than Andre Burger, who's the co-founder of Eppen-Burger Associates. They are they offer construction health and safety services. Andre, before I say hello to you, I just want to properly introduce you. So Andre is a registered professional construction health and safety agent. He's a mechanical engineer with 13 years experience at the Department of Labour as an occupational health and safety inspector, and a further 14 years private consulting in the construction industry. With more than 7,000 incident investigations to his name and many court appearances as an expert witness, he's got an in-depth understanding of the South African legal system, including criminal procedures and proceedings. Welcome, Andre. Really great to have you on board today.
Thanks, Marina. Great to speak to you guys. This is probably the closest I'll get to a dating site with so many women on this webinar. But yeah,
well, I'm not going to give you 2 minutes with each participant, unfortunately.
No, that's fine. Okay, so I've been asked to talk about the Act. So it's not a very interesting subject. I think next to sermon in church, this is probably the most boring subject. So I'm going to try and make it as interesting as possible, but it is legal compliance and legal responsibilities that we're talking about. So it's not supposed to be nice to hear, I think. Luckily, we've done away with the masks for today. From today onwards, back to the old normal. So yeah, so everything you do, if you get up in the morning, the OS Act is involved. I mean, everything you do is OS Act, OS Act. If you switch on the light, there was a COC issued for that light switch. So there's the OS Act involved. So you can't live without the OS Act, unfortunately. So it's just a bit difficult to understand sometimes when it is applicable to you. So I've got some extracts from the Act I would want to share with you guys. It's a different animal, the OS Act. You being an attorney should know that you're always innocent until you're proven guilty by a court. But the OS Act is a bit different. It's actually the other way around. You can be held accountable until you prove your innocence. So that is entrenched in Section 37 of our Act, which is the reasonable man test, which we got from England. So it's not a judge and a jury system like America, but it's an English system. So an employer can be held accountable. It also can assume stuff, which is also not a no-no in law. So our Act explicitly states you can assume that the employer is guilty, and it talks about vicarious liability. So if you do something wrong, Marina, I can be held accountable if I'm your employer, unless I can prove 3 things. So if I can just put that up to this on the screen quickly, let me just try and do that. I don't know if that's
while you're doing that, Andre, so basically if we set the scene on this whole thing, if there's a contractor that comes onto site at any body corporate or sectional title building, that space, that common property space, actually becomes almost a temporary workspace, not so?
Correct.
Okay.
So there's definitions in the Act for all of those things. So the body corporate, having the board of members, they can be held accountable as if they're a CEO. So anybody that performs work for somebody else immediately becomes a workplace, and that worker becomes your employee. And it actually goes, so 37(1) is the relationship between the employer and the employee. So it says here, whenever an employee does or must do an act which is between an offense in terms of this Act, the employer of such employee shall be accountable unless he can prove 3 things. So that is the reasonable man test. So you didn't act in your scope of your authority. It was under no circumstances allowed. So you didn't see it happen. And then you did everything in your power. All reasonable steps was done to prevent that act or omission. So those three things you have to prove in a court to prove your innocence. So that is why it's a bit different than other legislation. And also you can be held accountable for culpable homicide, even if there's no dead person. This is another unique feature in the OS Act. So if I drop a ton of bricks next to you, and by chance it misses you, you will be charged with culpable homicide because you could have died if that was like 2 inches to the left or to the right. So it will be seen as if you're dead, but you're not actually dead. So that's also another unique feature in the OS Act. So those are the 3 things that makes this a different animal. So we all have to deal with that. And then it speaks about your employer-employee relationship. And then in 37(2), it takes it further. The provisions of subsection 1 shall mutatis mutandis, you would know that Latin, apply in the case of a mandatory of any employer or user. So you mustn't confuse employer only with a workplace or a factory or whatever. It's anybody that's an employer or a user is employing somebody to do something for him, except if the parties have agreed in writing to the arrangements and procedures between them to ensure the compliance by the mandatory with the provisions of this Act. So this is where it becomes very critical. So when you get work done on your buildings, you must enter into a 37(2) mandatory agreement if you want to get rid of your legal obligations. So I always say, guys, you can have a standard template and pay R5 for it, but when something goes wrong, you're going to have to pay Marina a lot of money to get you out of trouble. So rather spend a bit of more time and money into these arrangements and procedures. And then it saves you a lot of headaches afterwards.
Andre, can I just butt in there? So basically what he's saying is the body corporate needs to get the section 37(2) agreement signed. So it's between the body corporate represented by the trustees and the contractor. Correct. And that would exclude liability for the body corporate if something happened and the contractor, became injured or whatever. And obviously, there's still public liability insurance involved. And also the good news is that I've already looked at a good agreement as well. If anybody's interested in that agreement, we're happy to share it at no charge. I've sent it out before to the Women in Sectional Title Network, but it's important to get it signed. So yeah, sorry, carry on, Andre.
Marina, yes, it's important that, remember that another thing about the OS Act, there's no insurance against it. It's a criminal act. So it's like taking insurance out on speed fines. There's no such thing as that. So you can't get out of the OS Act by having insurance. That's the first thing. And there's not a blanket exemption. If you sign something and say, look, you're responsible for the OS Act on our premises, and then you exempt it. No, that doesn't work like that. You must have an agreement in place where the two parties decide who's going to be accountable for what. So let's take a stupid example. So he comes in there and he needs a toilet for his workers. Now, can he use your toilet, or can he use, or are you going to pay him for his toilet? So those type of things must be in that agreement to make sure that the subcontractor or the contractor can comply. If there's nothing in that agreement, it will be deemed as if the first person, the body corporate, is at fault. Understand what I'm saying? So if you haven't agreed to that, then you become accountable. Same as if the CEO has got no agreement in place for his worker to be safe and he gets injured, then he will be charged. Then he has to go and prove that he's innocent. Okay, is that understood? Okay.
Yeah, I think so.
The OS Act's got 50 sections, which is the Occupational Health and Safety Act of 1993. It's got 50 sections in it, which is basically a lot of mumbo jumbo, because it just tells you all the framework of the Act, why it's there, committees, and stuff like that. But the actual working mechanisms of the Act is the regulations, of which we have 24 sets. So you've got asbestos regulations, you've got driven machinery regulations, electrical machinery regulations. One of those 24 sets of regulations is the construction regulations, which first saw the light in 2003. Then it was reviewed and updated in 2014, which is the current set of regulations we're working with. Now, in that set of regulations, it was the first time that specific legal duties and accountabilities was assigned to the client. Client being defined in the Act as a person for whom construction work is being performed. So that is not a person as such. It can be a body corporate, it can be a company, be that is my. Let me just get to the next screen, where the construction regulations, the duties of the client in the construction regulations. Now, this is where it gets interesting. I think I'm going to go through these because these are the nuts and bolts that must be in place when you do any construction work. So the client,
Andre, sorry, I just want to interrupt you here, because it's all very well that we talk about construction work. And I mean, a lot of bodies corporate, yeah, there are times when people have to come and do construction work, but would construction also not include other things? What else does the construction include? What about maintenance and demolition or things like that?
Yeah, definitely. While you mentioned that, let me just I didn't prepare a slide for that, but I'm just going to bring it up quickly and I'm going to read it to you guys. Because that's a big talking point in the industry, is the definition of construction work. I think if you're a lawyer, you can put anything in there. I'll give you a chance now. Construction work means any work in connection with. All right, that's the blanket. Then it says A, the construction, erection, alteration, renovation, repair, demolition, dismantling of or in addition to a building or any similar structure. And then B, the construction, erection, maintenance, demolition or dismantling of any bridge, dam, canal, road, railway line, runway, sewer. Okay, so basically the A and B is your construction of buildings and B is your civil works. So as you can see, what they've done is by adding those words in any working connection with, it broadens the whole thing. So the other day we had a problem just recently where a person fit an aircon unit onto a building and they fell through an asbestos roof. So the guy was 19, he died. So it's a hele gedoente now because there was nothing in place between the body corporate and that specific contractor. Even though it wasn't related to his aircon service, he was walking on this roof that was not safe. And no alternative arrangements was made for him to actually understand that. So you can see how complicated it will get when it goes to court, you know. So that is why we have this duties of the client now. The client is now obliged by law to prepare a baseline risk assessment for any intended construction work. So if you want to do something now, the client himself must now assess what the risks are, the broad stroke risks. I'm not saying he has to know what in that specific contractor's toolbox is and what's going to hurt him, but he must tell this guy, look, when you come and do this work, there's overhead electrical cables, there's gas lines in my building, there's asbestos roof sheets. Those are the strokes that you must paint. Then after this baseline risk assessment was done, the client must also draft a health and safety specifications document. So when he asks for this tender, for this work to be done, he must give that specifications document to the contractor so that he can also price for doing the job safely. So if he actually work on heights, you can tell him, look, we've got skyhooks, you can use a cradle, or you're going to have to build a scaffold, or this is how you can access these areas. So obviously that's going to have a cost implication. So that spec must be done and must be handed over to the contractor at tender stage. It says here at number F, include the health and safety specifications in the tender document. Or if you negotiate, obviously then you give it to him. Then, well, I'm going to go down this list, and you must stop me if I'm going to be too long, but this is the sort of duties that you must be aware of that's going to kick in when you do some maintenance work, Marina. Mm-hmm. So some of these items also relate to your duty towards the designer, which I don't think is going to be too applicable, so I'm going to skip those. Ensure that the potential principal contractors submitting a tender have made adequate provision for the cost of health and safety measures. So obviously now you get 3 quotes back. The guy priced this spec, and the cheapest guy, he's got naught. It's not going to cost him anything to. Then you must ask questions. You know, you can't just now award this tender to the cheapest guy, and he's made no provision. You're going to be held accountable because now you've got a legal duty to assess the cost that he allowed for compliance to the specification that you drew up.
Oh, I didn't know that actually. I wasn't aware that it went that far. That's interesting.
Yeah. Now, when it's over 60 million rand and longer than a year, you have to have a permit from the Department of Labor to do this work. So 60 million sounds like a lot, but I mean nowadays a double garage, it can be 60 million rand. So then when it goes to the Department of Labor for this permit, they actually want you to divulge this figure before they issue with this permit, the amount that you now established that was allowed for safety. So they don't give you this permit unless you can provide them with that figure. Then the next very important thing is to ensure that the principal contractor to be appointed has the necessary competencies and resources to carry out the work safely. So in addition to the quality, because normally it was quality and price. This was the only 2 things that was considered. But now you know that something on 2 legs is very unstable. So the 3rd leg they added now in 2003 was the safety thing. So you can't just take the best out that does the best work in the shortest time at the cheapest price. You must also make sure you can do it safely. So those are the 3 legs you must base your decision on, and you must be able to justify that decision. Because the other 2 is not legislated now. You don't have to take the best guy. You don't have to take the fastest guy. You don't have to take the cheapest price. But you have to take the safest person, if that makes sense. Okay, so you must do that. It says here that the principal contractor to be appointed has the necessary competency. So before you even appoint him, you have to assess certain things from him before you appoint him. And then if you've got more than 1 contractor on site, then the client has a duty to coordinate the whole lot together. That's number I. J, ensure that before work commences on site, that every principal contractor is registered and in good standing with the compensation fund and with license compensation insurer. So that's the WCA registration. So you must make sure that this guy has got compensation registration, injury on duty, you know, the WCA, workers' compensation. Appoint him in writing. So there has to be a letter that you appoint him in writing for this construction work. And then, very important, discuss and negotiate with the principal contractor the contents of the principal contractor's health and safety plan, and must thereafter finally approve that plan for implementation. So what this means is, now you've given him the specification, he must come back with another document, which is the plan, the health and safety plan, telling you how he's going to comply with the spec. Then the client must now evaluate and see if this is actually, these two documents are talking to each other. It's not a generic safety plan. It must have the specifics in there that you asked him to do in your spec. And then you must approve it. And then after that, you must audit him every month to see that he actually does what he said he was going to do in his plan. So that's monthly audits. Then you must make sure that the copy of this plan is available on site. Take steps to ensure that the plan contemplating 7.1 is implemented and maintained, and ensure that periodic health and safety audits and document verifications are done at intervals mutually agreed upon, but not less than every 30 days, or not more than 30 days.
So, Andrea, I just want to ask you as well. I mean, this is, I can definitely see the value of this as well, in terms of if you're getting contractors on site who are doing quite large construction works and things like that. But how do we know how far to go? I mean, if you're a managing agent, and I can just see the managing agent sitting out there today with their eyes rolling and thinking, oh my goodness, we've got so much to do, and now we've got to tell the trustees to do all this as well. What if I just want to get a little plumber to come out and just fix a leaking pipe on common property? I mean, is that just, do you have to assess the actual risk before? I mean, surely the legislation doesn't want us to do all of this, or does it?
No, look, that is where the debate is at the moment. What is now defined as construction work? Is it now like doing a satellite dish? Is it now fixing a plumbing problem? So it's not, it must be anything, it must be something to do with the construction of the building. Then it will be deemed, so if you paint your building, if you put new windows in or that type of thing, understand? Then it will be deemed construction work. So what I advise the body corporates is to do a, let's call it a generic specification, which deals with the normal maintenance issues. You know, you can put all of them into that one document. At least when you do the routine maintenance stuff, you've got a document to give this guy to tell him, comply with X, Y, and Z. You've got something, but you can't have nothing.
Yeah, there's definitely going to be like a policy, like even when we dealt with Poppy, that Poppy Act and all of that, there's a policy for everything, policy for health and safety. Yeah.
Well, you write your own laws basically in that specification, so you can tell him how safe you want him to be. That's basically what it means.
Yeah.
Good. So that is, well, I'm sure you guys can, I can send you these slides and then you can distribute. They can read these things. I mean, it's boring to go through some of these issues, but you have to know them. Otherwise, you can't comply with them. If it's unclear to your members, they're welcome to phone me and ask for advice.
Oh, that's very kind. I just want to go back one step as well. We're talking about the Occupational Health and Safety Act. I probably should have said it at the beginning, but you know, it obviously does apply to sectional title. I mean, you've got Section 3(1)P of the Sectional Titles Act, which stipulates that you've got to, the trustees must ensure compliance, or there's the body corporate must ensure compliance, but then it delegates that responsibility to the trustees in Section 7, must ensure compliance with any law relating to the common property. And again, Section 3(1)T says that the trustees must control, manage, and administer common property for the benefit of all the owners. So it goes without saying that this act is 100% applicable to sectional title.
Yeah, no, definitely. There's no question.
Okay. Also, I wanted to ask you, do you need different permits for different things?
No. The only distinction where the permit comes in is for the Department of Labour to actually monitor construction activities, they've got two categories. One is a notification only. So for minor works, you just notify, the principal contractor must notify the Department of Labour. So you don't even have to tell him that, it's his legal duty. So if he comes to your site, he needs to notify the Department of Labour that he's going to do construction work. Then if it's above 60 million rand or longer than a year, the construction period, then the client must apply for this permit from the DOL, in which he must deliver a whole lot of documents. So I don't know if you guys are involved in that big construction activities, but then this is where we come in. Then the registered agent must actually be in charge of the whole process. So only an agent can do a permit application, and the agent must manage the project after that. So the client now, you can also appoint a safety agent if it's less than that, but you're obliged to do it if it's more than 60 million rand.
Yeah, yeah,
So
that might be in exceptional cases. Yeah, exceptional cases. Cecile asks, if all this is not in place, and I assume you're also looking at the agreement and all these obligations, can trustees be held personally accountable in the case of injury or death? Well, I think that's a great question, Cecile. And the bottom line is that the trustees have a fiduciary duty to the body corporate. Duty used to be based on you could be sued in your personal capacity if you were grossly negligent, or if there was fraud, or you were convicted of fraud. But gross negligence was very difficult to prove. With the new Sectional Title Schemes Management Act, that changed. And if there's a breach of your fiduciary duty, that's all. If there's a breach of your fiduciary duty, you can be held accountable. So yeah, I think whilst the body corporate can get off the hook for if you sign these agreements, I still believe the trustee liability is pretty strong there if you breach your fiduciary duty and you haven't taken all the necessary steps to protect your complex. And that would obviously be a separate kind of case. You can't contract out of everything. You can't contract out of certain liabilities.
Yeah, Marina, and look, I've been in court lots of times when I was working for the Department of Labour, and fortunately, when we charge somebody, let's take an employer-employee relationship, which is easier to explain. So something went wrong in the factory and somebody got injured or killed, then we charge the entity, which is the company, as represented by the CEO. But in most cases, it will be the company that gets the sentence. And not the actual CEO, unless you say he was grossly negligent and not dispersing his duties, then he will be held accountable in his personal capacity. So the CEO is, the members of the board, obviously a death thing can't be held accountable for anything. So the people involved is normally responsible.
And I just have to just mention that the Companies Act specifically doesn't apply in sectional title. Okay. So the trustees would definitely be held liable at the end of the day if they if this happened.
No, they become sort of the CEO or the management structure.
Yes.
Similar to what a board member will be in a normal company.
Yeah, wanted to ask you now, when we chatted last time, you mentioned to me about asbestos, and it's quite relevant even today, because we've got a building next door to us that I know there's a problem at the moment where they're wanting to get rid of the asbestos, the employees in the building, and then it seems to be quite a process. There we go. You thought that out, the inventory of asbestos.
Okay, so the most important thing now is that they want to get rid of asbestos. They don't want just to contain it anymore. So the new regulations is actually called the asbestos abatement regulations. So the government now decided, no, we're not going to live with this stuff anymore. As soon as you want to fix it, as soon as you remove it, you can't replace it. So if it's in a state of it needs a repair, you unfortunately have to remove it. You can't even clean it and paint it anymore. So that is why there is now, the starting point is this inventory of asbestos in a place. You can see it's not only a workplace, it's a place. So you have to assess if you have asbestos in your building, where it is, there's specific rules here stipulated in this document, which is under number 4 in asbestos abatement regulations. So this inventory, it doesn't have to be a specific registered person, but it must be a competent person to identify where this is, and then you have to do a specific inventory, and it tells you what must be in this inventory. The date on which the material was identified, a description of the material, quantity and extent of the deterioration, so how bad is it, the location as detailed in a floor plan, so you have to have a drawing indicating where it is, confirmation of labeling and signage as required by regulation 20. Okay, so that's just refers you to another regulation which tells you what that means. The risk categorization derived from the asbestos risk assessment as detailed in regulation 5.3. I'll scroll down to that just now. But this is my point. So if you have a aircon guy coming onto the roof and you haven't got this risk assessment where you've checked the asbestos, what state it is, can people walk on it, you can't tell him you must avoid it or whatever. So if he gets killed there, you're going to be in trouble because of this regulation. So lots of these regulations are sort of intertwined with each other. Let me just get rid of the sun. Sun can sun. Okay, so you must categorize the risk of that specific section of asbestos, and then the description of potential exposure scenarios as required in regulation 6.2b. So how will people be exposed to this risk now? In your cases, it will be mostly be contractors. Some older buildings have boilers, and you've got the insulation, which is especially bad. If you just have, they also categorize it in different categories. So if you have roof sheets or gutters like that, it's a low risk. So it can't somehow give off fibers into the air, because it's actually the fibers in the air that gives you the cancer. And interestingly enough, only one asbestos fiber can give you cancer. It's called a regulated fiber. So the length, the ratio to the thickness ratio must be a specific ratio. And if that specific fiber hits your lungs, then it sticks in there, it can give you asbestosis. So that is why it's so dangerous, and I have to remove it now. Okay, so
and the removal process as well. The removal process was also quite interesting.
Yeah, that's complicated.
You have to get your guys out of the building.
Correct, and then an asbestos inspection authority must be, there to monitor the air quality. So they put monitors on the workers, and they put stationary monitors all over the place, and then they can see what the levels are in the atmosphere. Because if there's these guys working on the roof and they've got their moon suits on, the neighbors will phone the Department of Labor and say, look, there's danger here, we're going to get killed because these oaks are walking around with their suits and we are all exposed. So it's very complicated and it's very expensive. It's not cheap.
You mentioned the Department of Labor, Andre. What are they going to do to me if I do nothing about my asbestos in my roof?
If they find you, then they will do something. But if they don't know about it, unfortunately, nothing.
Yeah.
The thing is, when somebody gets sniff of this and they found them and you haven't got your assessment, you haven't got your... Because this is the asbestos regulations is basically the construction regulations. So you must also hand in a plan to the Department of Labor. They will approve the plan and then you can proceed. So there's a process for that as well.
And,
so
the penalties, what penalties are there?
A very good question. Until a couple of years ago, there was a monetary penalty for all the regulations, which has been scrapped now. They've only put in jail sentences in, and then that will be converted to a monetary penalty by the judge himself. So it's only jail terms, and then the judge must decide in this day and age, because some of these regulations are 30, 40 years old, So there's 200 penalty that wasn't working out for them. So they changed it to a jail term, and then the judge converts it to a monetary penalty.
Yeah, serious stuff.
Yeah.
I think, doesn't it always? I'm sure also in your time when you were an inspector and in the courts as well. I certainly find that people don't take this act seriously enough. In sectional title in my industry, it's almost fobbed off or pushed to the side. And it's only when you see things on TV, like, you see Grenfell Towers happening there in England, or that other building that's completely subsided the other day in America, that you realize, gosh, these are huge consequences. They're big consequences for non-compliance with this kind of act.
Marina, let me be honest with you. I don't know. I'm not a politician. I don't want to talk about them, but the government unfortunately don't have enough people and competent people to regulate all these things. Unfortunately, let me compare it to a speed fine. You've got people running around at 120 in one the whole day, but there's like 50% of them that will do more than that. Nothing will happen to them unless there's a policeman there on that day. So he will catch you, and you can't go and tell him, look, there's a lot of other guys also running around somebody else at 200 km an hour, They will just focus on you, but it's the luck of the draw. So I'm not telling you they're going to be at all your sites. They won't. But what will happen to you will be the full might of the law if they catch you. So unfortunately, that is the case. It's not as policed as it should be, but let's not focus on this one guy. He will get the full might of the law, and they'll dig into these regulations for every little word. I mean, we read these things word for word and find out who is responsible. We normally charge more than one person as well. This is also very interesting. I always compare it to the Department of Labor. They will line up 5 people in a row, and they'll shoot with a gun, what is it called again? The one that fires all the small bullets. The big guy. And then the guy that can't duck the bullets, he will get shot. This is exactly what happens. So they will charge more than one person, and then maybe 1 or 2 will be found guilty. So no, it's not nice in the court of law.
No.
This risk assessment that I referred to previously, it actually tells you what the categories, how you categorize this. So the health impacts of the asbestos, so you get different types of asbestos. So some of them have different impacts on your health. The number of persons potentially exposed at the workplace, the potential or damage or disturbance of asbestos-containing materials at the workplace, also by maintenance activities, potential incidents, and normal occupant activities. The condition of asbestos-containing material, including state of deterioration. So that must be in your risk assessment. So I would advise that the body corporates at least get this inventory in place, so that whenever there's maintenance work to be done and people come into contact, so if they're in roof voids, there's isolation material there, it might have asbestos in them. And then, well, I don't even want to tell you what a lawsuit is for asbestosis cases.
No, it's just shocking. I think when you look at it, yeah, no, it's horrible. We actually know a few people who've passed away from that quite recently.
Yeah, well, the lucky thing about asbestosis, you only die 20 or 30 years later. So
yeah,
that's unfortunately, you can't see. It's not like cutting off your finger. It's a long-term process. Then I've got one last slide here, which is also a document that you must prepare if you're the owner of a structure. So it's also found in the construction regulations. There's some duties there when you do structures, and then the second part here, the owner of a structure must ensure that inspections of that structure are carried out periodically by a competent person in order to render the structure safe for continued use. That inspections contemplated are carried out at least once every 6 months for the first 2 years, and thereafter yearly.
So is that for something like a lift?
No, that's the whole building.
The whole building?
Yeah, the building, the structure. So it's got nothing to do with the nice aesthetics. It's got to do with the structure is safe. It's all the balustrades still fine, is a lift not coming loose in the shaft, whatever. The structure is maintained in such a manner that it renders safe for continued use. So you must also consider improvements to your buildings where it's becoming unsafe to use. And then you must keep
the one thing I wanted to mention to you, I was in New South Wales a couple of years ago, and they've got really strong thoughts and feelings about windows that can't be open for X amount of centimeters, because they had people jumping out of their high-rise strata buildings. Do we have anything like that here?
Yeah, look, that is not in the OS Act, that's in the National Building Regulation. So there is this 100 by 100 rule where a ball of 100 can't pass through anything when it's there for protection. So if the window is higher than a meter, which is a balustrade height, then it's fine. But if it's lower than that, you can't have anything 100 by 100 pass through that obstruction now. Okay. But I'm not an expert on that, Marina. That's in the that's in
the National Building Regulations.
Yes,
also, just one thing I want to also mention while we're talking, I don't mean to interrupt, but I need to raise these things. Also, something like fire hydrants. I know also not a speciality, Andre, but just please be careful, guys. You know, fire hydrants are very, very important on each floor of a sectional title building. And if that fire hydrant isn't there and there's a fire and something happens, also trustees can get into big trouble there.
Yeah, look, there is a little bit of that in the OS Act as well. So whenever there is infrastructure for fire, you're not allowed to obstruct it. So the main thing is not to obstruct fire hydrants or fire extinguishers and keep them regularly serviced. So the fire extinguishers must be serviced once a year, and the hydrants must also be checked. I don't know actually the intervals there. But yeah, and it's also a good thing to have an evacuation plan in place with a siren. So, Marina, that's basically what I've done. If there's any questions, I'll be happy to.
Glennis just says, do balustrades form part of common property? And if so, does the inspection fall to the owner or to the body corporate? Balustrades are definitely part of common property, Glennis. And so, yeah, that would be a part of the inventory. And in fact, in an interesting case in Australia, in Sydney, in a retirement village, they made the body corporate change their balustrades because of the fact that they were climbable. I don't know if they were, I don't think they were climbable by the residents of the retirement village, but certainly by their grandchildren. So they made them change those balustrades to become safe. So yeah, trustees do have work to do in terms of looking at what's going on within the scheme at any given time. And these reports do need to be done. Anyway,
can I just mention something about the OS Act? Okay, people always ask me, can we bend the OS Act? It's already bent. The OS Act is the minimum requirement. So if it says there, a balustrade must be 1 meter in height, you can't have it 980. That's the minimum. So we had, I was involved in Villa Italia in Century City, and after we installed all these balustrades and did the screeds, then the balustrade was 980. We had to raise those balustrades to be a meter.
Sure.
Yeah.
Yeah, that's interesting. Gosh, I think you must have seen quite a few different things in your time over the last years.
Marina, I'm totally saturated with deaths. I've seen too many dead people. Maybe I'm paranoid now, but yeah, one death. I mean, we had people falling through manholes. We had another child now in Gauteng, I think, 9 years old, falling into a manhole. So yeah, you don't want to have one of those. I mean, we have too many of these.
Yeah, it's too easy to talk about these things after the fact, and everybody has all these regrets, etc. And that's why I don't want it to be fobbed off. We need managing agents, portfolio managers. You need to speak to your trustees and educate them. And perhaps if you're interested at any time in having a small seminar or anything for trustees on the specific topic, we all need to get together. We can all get all the lady attorneys, and we can bring in other people to talk about it, because we really, really do need to pay more attention to it. Andre, thank you so very much for your time today. I think we're coming to the end of our webinar now, and we really appreciate your expertise and value the fact that you've taken the time to come and speak to us. Please remember that this is a recording as well. If you go onto the videos page of our Women in Sectional Title website, you'll see all of our webinars over the last almost year. I can't believe we're saying that. So yeah, I think let's go forward. Let's move forward. Apparently, we might be in for some snow here in Gauteng. So if you are in Gauteng, keep warm. If you at the coast, yeah, just enjoy your weather. And we really, really look forward to seeing you the next time on our Women in Sectional Title webinar. Thank you so much, everybody. Thanks, Andre. Take care.
Yeah, okay, Marina. Cheers.